The phone rings, and your stomach drops. It might be a number you do not recognize, or worse, one you have come to dread. The voice on the other end is firm, demanding, relentless. They are a debt collector. They call you at home during dinner. They call you at work, causing you embarrassment. They send a blizzard of letters with bold print and urgent warnings. This constant pressure creates deep stress and helplessness. You feel trapped in a cycle of anxiety, isolated and overwhelmed, facing a powerful, unyielding force alone. No clear path to resolution or peace. This is incredibly common. The feeling of powerlessness is a heavy burden. The calls can disrupt your daily life. They can strain your relationships. They can take a toll on your mental well-being. It's easy to think you must endure the harassment or give in to demands you can't meet or don't understand. But this is not the case. The law gives you specific rights and protections. You have the right to question the debt. You have the right to demand proof. You have the right to tell them to stop contacting you in certain ways. You can assert these rights without a lawyer or stressful calls. One carefully worded letter can stop the calls and shift the balance of power back to you. That letter is a formal, documented request collectors must respect. It can force them to stop the phone campaign. It can require them to validate the debt they claim you owe. That gives you breathing room to assess things calmly. This guide will walk you through the whole process. This letter is your first line of defense. It's not a magic wand that makes debt disappear, but it's a powerful legal tool that puts the brakes on collections. It signals you know your rights and will stand up for them. Follow the straightforward steps to create a legal record, protect yourself from unfair practices, and control how and when you're contacted. We'll show you how to write the letter, how to send it, and what to expect next. To effectively challenge a debt collector, you must first understand the rules they are required to play by. A federal law called the Fair Debt Collection Practices Act, FDCPA, outlines exactly what collectors can and cannot do. This law is your shield. It protects you from abusive, unfair, deceptive collection practices. For instance, collectors are forbidden from calling you before 8 a.m. or after 9 p.m. in your local time. They cannot call you at your place of work if they know or have reason to know that your employer prohibits such calls. They are also not allowed to harass you by using threats of violence, obscene language, or by repeatedly calling to annoy you. The FDCPA also serves as your sword, giving you the power to take offensive action. One of the most significant rights it grants you is the right to dispute the debt and request validation. Within 5 days of their first contact with you, a debt collector must send you a written notice that includes the amount of the debt, the name of the creditor to whom the debt is owed, and a statement informing you of your right to dispute the debt within 30 days. If you send a written dispute or a request for verification within that 30-day window, the collector must cease all collection activities until they have mailed you proof of the debt's validity. This right to demand verification is the core principle behind the powerful letter you will be writing. It forces the collector to pause and do their homework. They can no longer simply pressure you with phone calls. They must now produce tangible evidence that you owe the money and that they have the legal authority to collect it. Furthermore, the FDCPA gives you the right to stop their communications altogether. If you send a collector a written request to cease contact, they are legally barred from contacting you again, with a few exceptions. They can contact you to tell you they are stopping their efforts or to notify you that they are taking a specific action like filing a lawsuit. Knowing these rules changes everything. It transforms you from a passive recipient of demands into an active participant who can direct the flow of communication. The collector is no longer in complete control of the situation. When you put your requests in writing, you are creating a paper trail that documents your assertion of these rights. This documentation is invaluable. It serves as your evidence if the collector violates the law and you decide to file a complaint with a regulatory body like the Consumer Financial Protection Bureau, CFPB, or even pursue legal action against the agency for their transgressions. Before you can draft your powerful letter, you need to arm yourself with the right information. Acting on impulse without proper preparation can be less effective, so taking a few moments to gather some key details is a critical first step. Think of this as assembling the raw materials for building your defense. Start by finding any correspondence you have already received from the debt collector. This letter or notice is a goldmine of information. It will contain the name, it will contain the address of the collection agency. Next, look for any specific numbers that identify your case. The collector's letter will almost certainly contain an account number or a reference number that they have assigned to your file. This number is essential. It lets the collector find your records quickly, so include it in your letter. Also, make a note of the exact amount of money they claim you owe. Jot down the date you were first contacted by the collector, if you can remember it. Your right to request debt validation is strongest within the first 30 days of that initial contact. You can still send the letter after 30 days, but within that window, the collector must pause their activities. Finally, get your own information straight. Write down your full legal name and your current mailing address exactly as the collector has it. Once these facts are on a single sheet of paper, you are ready to move forward. This simple act of organization is practical and psychological. It demystifies the situation and replaces chaos with a sense of order and control. You are no longer just reacting to a stressful phone call. Instead, you are methodically preparing a calm and professional response. This preparation builds your resolve and protects your rights and financial well-being. The effectiveness of your letter lies in its clarity, its firm tone, and its specific legal requests. This is not the place for emotional appeals, long stories explaining your financial situation, or angry accusations. A powerful debt validation letter is professional, direct, and focused on two primary objectives: demanding proof of the debt, controlling future communication. By keeping the language simple and sticking to the facts, you create a document that is legally potent and difficult for the collector to misinterpret or ignore. The goal is to be assertive without being aggressive, and clear without revealing any unnecessary information. The first key component of your letter is the request for debt validation. This is a formal demand for the collector to provide specific evidence that substantiates their claim. You should not just vaguely ask for proof. Instead, you should request specific documents. Copy of the original signed contract or agreement that created the debt. A complete accounting from the original creditor showing all charges and payments. Proof the collection agency has the legal right to collect. For example, a bill of sale showing they purchased the debt. This level of specificity makes it harder for them to respond with a generic, unhelpful statement. The second critical component is the cease and desist communication request. The FDCPA gives you the right to tell a collector to stop contacting you. You can tailor this request to your needs. For example, you can demand that they cease all communication entirely, or you can specify the method. A very effective strategy is to demand that they stop all telephone communications. You can state, "I demand that you cease all telephone contact with me at my home and my place of employment." This simple sentence legally obligates them to stop calling you. You should then instruct them that any future communication must be in writing and sent to your mailing address. It is equally important to know what not to include in your letter. Critically, you must not admit to owning the debt, not even implicitly. Avoid using phrases like, "my debt." Avoid using phrases like, "the money I owe." Instead, always refer to it as the alleged debt, or the account you are attempting to collect on. Admitting ownership of the debt, especially if it is old, can inadvertently restart the statute of limitations. The statute of limitations is the time limit for a creditor to sue you. Stick to the facts, make your legal requests clearly, and end the letter. Do not make promises to pay. Do not provide any personal financial details like your bank account information. Do not provide your social security number. Using a template is the easiest way to ensure your letter includes all the necessary elements and maintains a professional tone. The The model below is designed to be clear, concise, and legally effective. All you need to do is fill in the bracketed information with the details you gathered in the preparation step. Remember to keep a copy of the final signed letter for your personal records before you send it. This copy is a crucial part of the paper trail you are creating to protect yourself. This template is your starting point for taking back control of the situation in a calm and documented manner. Here is a straightforward template you can use. Simply copy the text and replace the bracketed information with your own specific details. Do not add extra paragraphs or emotional language. The power of this letter is in its directness and its reliance on your legal rights. It is a business communication, not a personal one, and should be treated as such. Its purpose is to make specific legal demands that the collector is required by law to follow, so every word is chosen to support that objective without adding any confusing or unnecessary information. Your full name, your street address, your city, state, zip code, date, via certified mail, return receipt requested, debt collector's company name, debt collector's street address, debt collector's city, state, zip code, account number, insert account or reference number provided by collector, to whom it may concern. I am writing in response to your attempts to collect on the above referenced alleged debt. Please be advised that I am disputing this claim. This letter serves as my formal request for complete validation of this debt pursuant to the Fair Debt Collection Practices Act, 15 U.S.C. paragraph 1692g(b). Please provide me with documentation that substantiates your claim, including a copy of the original signed contract or agreement with the original creditor that created this alleged debt. Furthermore, I hereby demand that you cease all telephone communications with me immediately. Do not call me at my home on my mobile phone or at my place of employment. All future communications regarding this matter must be made in writing and sent via postal mail to the address listed above. Be advised that any telephone contact after you receive this letter will be considered a violation of the FDCPA. Please govern your actions accordingly and confirm your compliance in writing. If you are unable to provide the validation I have requested, you must cease all collection efforts on this alleged debt immediately and inform all credit reporting agencies to which you have reported this account that it is disputed and must be deleted from my credit file. Your failure to respond to this validation request within 30 days may be reported to the appropriate federal and state agencies as a violation of the law. I am maintaining a record of all correspondence regarding this matter. Thank you for your professional cooperation. Sincerely, your printed name, your signature. This template accomplishes everything you need it to. It clearly states that you are disputing the debt, which triggers your legal rights. It makes a specific request for validation, putting the burden of proof on the collector. It explicitly demands an end to phone calls, giving you immediate relief from harassment. Finally, it establishes a professional and serious tone, signaling that you are aware of your rights and are prepared to defend them. By using this structured format, you ensure that your message is delivered with maximum legal impact and minimal room for misunderstanding. So, that's it. The official send-off. How to mail your letter for maximum impact. Now that you have crafted the perfect letter, how you send it is just as important as what it says. Simply dropping it in a mailbox with a standard stamp is not enough. You need undeniable proof that the debt collector received your letter and the date they received it. This proof is your ultimate defense. If the collector later claims they never got your request, or if they continue to call you in violation of the FDCPA. Without this proof, it becomes your word against theirs. The proper mailing method creates a legal record they cannot deny. The best method is the United States Postal Service. Use certified mail with return receipt requested. This service gives you two crucial pieces of evidence. First, a mailing receipt with a tracking number when you send the letter. That receipt proves you mailed something to the collector's address on a specific date. Second, a green return receipt postcard mailed back to you after delivery. The postcard will be signed by an employee at the collection agency, confirming the delivery date. At the post office, you must fill out 2 forms. PS Form 3800, certified mail. PS Form 3811, return receipt. The postal clerk can help you. Affix the forms and labels to your envelope. The cost is a few dollars more than a first-class stamp, but the legal protection is invaluable. Once home, file away the stamped certified mail receipt and the green return receipt card when it arrives. Staple them to the copy of the letter you kept. This complete packet is your ironclad proof. If you absolutely cannot afford certified mail, use a tracked service like USPS Ground Advantage. At minimum, request a certificate of mailing from the post office. It proves you sent the letter but not delivery. Certified mail with return receipt is the gold standard. Never send original documents. Never send the letter via email. Never send the letter via fax. The aftermath. What to expect. After the letter is sent. After you have mailed your letter, a period of waiting begins. Have realistic expectations about what might happen next. The collector has received a formal, legal demand and must decide how to proceed. Generally, their response will fall into one of 3 primary categories. Category 1, silence. The phone calls may stop. You might hear nothing further from the agency. This is very common. Reason 1, they may not have the validation documents you requested. Very old debts, debts sold multiple times. It may be more trouble than it's worth for them to chase records. Reason 2, they may decide you're not an easy target. You signaled you know your rights. They may move on to someone else. Category 2, compliance. They send a validation packet. It may arrive a few weeks after they receive your letter. When it arrives, review it carefully. It should contain more than a simple printout with your name and amount. Scrutinize to confirm the debt is yours and the amount is correct. Next section will show how to analyze this and what to do if you still disagree. Category 3. They ignore your letter and continue collection in violation of the law. They might keep calling. If that happens, your record keeping is your strongest tool. Document every call that comes in after they should have received your letter. Note the date. Note the time. Note a summary of the conversation. Keep your certified mail receipt proving they got your cease and desist. That creates clear evidence of an FDCPA violation. Use that evidence to file a formal complaint with the CFPB. File with your state's attorney general. You may even have grounds to sue the collector for damages. Navigating the collector's response. When they send proof. If the debt collector responds by sending you a package of documents, your work is not yet finished. This is the moment to act like a detective and carefully examine the evidence they have provided. Do not be intimidated by a thick stack of papers or official-looking printouts. Your goal is to determine if what they sent actually constitutes legal validation of the debt. A simple summary statement that they printed from their own system is not sufficient proof. You are looking for concrete evidence that links you to the original debt and proves the amount they are claiming is accurate. Start by looking for a copy of a contract or agreement with your signature on it. For a credit card debt, this might be the original cardholder agreement. For a loan, it would be the signed loan note. This is the strongest evidence of an original agreement. Next, review any billing statements or account summaries they have included. Do these documents come from the original creditor? Do they clearly show how the total amount was calculated, including any interest, late fees, or other charges? Compare the amount they claim with the last statement you may have from the original creditor to check for discrepancies. You must also verify that this specific collection agency has the legal authority to collect the debt from you. Debts are often bought and sold between different agencies. The documentation should include a chain of assignment, showing how the debt traveled from the original creditor to the current collector. If there are any gaps in this chain, their legal standing to collect from you could be in question. Also, check all the dates carefully. Every state has a statute of limitations, which is a legal time limit for how long a creditor or collector has to sue you over a debt. If the debt is older than the statute of limitations in your state, they cannot win a lawsuit against you. If, After reviewing all the documents, you find that the proof is weak, incorrect, or incomplete. Your next step is to send a follow-up letter. In this second letter, you will clearly state why you believe their supposed validation is insufficient. For example, you might write, "The documents you provided do not include a copy of the original signed agreement. The amount you claim is incorrect, as the statute of limitations for this type of debt in my state has expired. If the debt is appearing on your credit report, you should also file a dispute directly with the credit bureaus, Equifax, Experian, TransUnion, including copies of your correspondence with the collector." Your path forward. Staying organized and reclaiming your peace. Taking this single step, sending one well-crafted letter, is a monumental move toward reclaiming your financial peace. You have successfully shifted the dynamic from one of passive anxiety to one of active, informed control. The journey may not be over, but you have built a firm foundation for whatever comes next. The most important practice to continue from this point forward is meticulous record keeping. Create a dedicated file folder for this specific debt. Copy of the letter you sent, certified mail and return receipts, any and all correspondence you receive from the collector. This file is more than just a collection of papers. It is your shield and your story. If you ever need to speak with a consumer law attorney, file a complaint, or defend yourself in court, this organized file will be your greatest asset. It tells a clear chronological story of your attempts to resolve the issue responsibly and legally. Continue to document everything. If the collector sends another letter, add it to the file. If they violate the law and call you, make a detailed note of the call and add that to the file as well. This diligence demonstrates that you are serious and prepared. Remember the common mistakes to avoid. Do not be tempted to make a good faith payment on a disputed debt just to make them go away, as this can reset the statute of limitations. Do not provide sensitive personal information over the phone. If you eventually decide that the debt is valid and you want to settle it, always get the settlement agreement in writing before you send any money. The written agreement should explicitly state that your payment will satisfy the debt in full. This prevents them from coming back later and claiming you still owe a remaining balance. You are not powerless in this situation. The law provides you with clear rights, and by using them, you have taken back control. Your final checklist is simple. Keep your records organized. Review any documents you receive with a critical eye. Do not be afraid to seek further help if needed. Free resources are often available from legal aid societies, nonprofit credit counseling agencies,